Hello, I'm Chris Gilliland, President of William Douglas Management Company. Today we're going to discuss proxies. Proxies play an important part in many association membership meetings. This is especially the case when associations have high quorum requirements and low membership meeting turnout. Because association governing documents can vary and individual state statutes can also vary, the following information is a general outline of the use of proxies within homeowner association meetings. A proxy is the formal authority given to another party by an association member to act on their behalf in their absence, generally at an association meeting. This party may or may not necessarily be a member of the association. Proxies cannot be used for board of directors meetings since this would constitute a delegation of fiduciary responsibilities that cannot be delegated. While there is typically no standardized proxy form, in most instances this authority must be given in writing. However, there could be exceptions to this written requirement. The written proxy form must be signed by the member, either personally or by the member's attorney-in-fact. Generally speaking, a proxy form in electronic format that bears the member's electronic signature is considered valid. A proxy is generally effective when accepted and filed by the association secretary. Proxies can be written to be valid for a particular meeting or a longer time period. This time period can vary according to the association's governing documents or state statute. Generally speaking, a proxy is revocable by the member who appointed the proxy. Some governing documents and some state statutes allow for and some prohibit the use of irrevocable proxies. A proxy is revocable by the appointed member attending the meeting and voting in person, or by the member delivering a written statement to the board secretary revoking said appointment. A proxy can also be revoked by the member submitting a succeeding proxy, which would automatically revoke the prior proxy when accepted and filed by the association secretary. What wording comprises a proxy form can vary. However, a proxy form should have a similar phrase to the following: I, John Smith, appoint Jane Jones as my proxy. Then a place for the member to sign and a date the proxy was signed. While state statutes and governing documents may have additional requirements, this wording would generally be the minimum. Unless the governing documents or state statute mandate a specific proxy form, the board secretary would generally accept other forms. Two primary concerns often arise when it comes to the use of proxies. First, members submit proxies and do not attend meetings or less informed. The second concern being members obtain vast numbers of proxies and influence membership votes. States and some associations have implemented limits on the use of proxies in attempts to reduce these two concerns. It is not uncommon for associations to amend their bylaws to prevent members from bringing more than a set number of proxies to any meeting. The state of Arizona implemented legislation that severely restricts the use of proxies in favor of mail-in ballots. If the association governing documents and state statute allow, there are two types of proxies. First is the general proxy. A general proxy allows the appointed member the authority to vote as they see fit regarding any business brought up at a meeting. The second type of proxy is called a limited proxy. With a limited proxy, the member directs the appointed proxy holder on how to exercise the proxy.